Welcome back to Lost Dash Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss whether a warrantless search by the probation officer of the defendant's cell phone was unreasonable under the Fourth Amendment. And before we discuss the Ninth Circuit case, I want to thank you for watching me on YouTube and subscribing. And if you're listening to the podcast version of this recording on Audible or Spotify, give my podcast a 5-star review rating. And finally, if you're interested in supporting my channel, please think about going on my website at lostdash.com and purchasing one of these t-shirts or some other merchandise that I have on that website. And during the month of December, you could put in the code THANKS2022 to receive a 10% discount. Thanks for watching, and let's go ahead and discuss this case.
Quick message from Lost Dash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Dash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Dash YouTube page. That's LAWSTACHE.
Today we'll discuss United States v. Lara, which is a Ninth Circuit case that deals with the search of a cell phone. Two probation officers arrived to Mr. Lara's home because he failed to check in and report to probation. During a cursory search of the home, they see a cell phone that's laying on a table next to Mr. Lara. Without Lara's objection, but also without his permission, one of the probation officers opens the cell phone and looks at one of the latest conversations. There, Mr. Lara sends a picture of a firearm to somebody by the name Al. Al responds whether the firearm is clean. Lara says yep, and then Al asks him how much. Based on this information, the probation officers do a second look at the apartment. They don't find the firearm, but they do find a foldable knife. They arrest Mr. Lara for violation of his probation terms because he could not possess such a knife. The officers then take the cell phone to a forensic lab, and they figure out that the picture of the firearm was taken at Lara's mother's home. With picture in hand, they go to the mother's house, they show the picture, and she directs the officers to the room that has similar or the same curtains. The officers then look around, and in the closet of that room, they find the particular firearm. Mr. Lara is charged with being a felon in possession of a firearm in violation of 922G, but he now files a suppression motion and says that the search of his apartment, of the cell phone, and later using that information to find a firearm at his mother's home was in violation of the Fourth Amendment. Remember, the Fourth Amendment protects you against unreasonable searches and seizures, meaning that generally speaking, officers need to have a warrant before they can search or seize you. Here, of course, the probation officers did not have a warrant. But the question is, did the conditions of Lara's probation allow the probation officers to search his home, including his cell phone? In Riley v. California, the Supreme Court held that police generally may not, without a warrant, examine digital information on someone's cell phone which was seized incident to a lawful arrest. But here, of course, we're dealing with somebody on probation. And the government argues that Mr. Lara accepted the terms of this search when he signed the terms of his probation and acknowledged them. Now, the first thing that the Ninth Circuit does is explain that simply being on probation and agreeing to the terms of probation doesn't necessarily make the search a reasonable one. While the Fourth Amendment protects you against unreasonable searches and seizures, in order to determine whether a search is reasonable or unreasonable, we have to balance the degree to which the search intrudes on your right to privacy against the degree to which the search is needed to promote governmental interest. So here's what the court does. They look at Lara's interests against the government's. First, let's look at Mr. Lara. The Ninth Circuit quickly identifies three most important factors when dealing with Lara's interest. Number one, his status as somebody on probation. Number two, the clarity of the probation terms as explained to Mr. Lara. And finally, the nature of the contents found on Lara's cell phone. When dealing with somebody on probation, the Ninth Circuit explains that because Mr. Lara was on probation, his reasonable expectation of privacy is lower than someone who has completed probation or who has never been convicted of a crime. But while the privacy interest of probationer has been significantly diminished, it is still substantial. Moving on to the second issue, the clarity of the probation terms, the court finds that the cell phone search condition on Lara's probation was not clear. After all, he agreed to submit his person and property, including any residence, premises, container, or vehicle under his control, to a search and seizure. But none of the terms, in particular, neither container nor property, clearly or unambiguously encompasses his cell phone and the information contained therein. Lara's cell phone was not a container. The Supreme Court wrote in Riley that treating a cell phone as a container whose contents may be searched incident to arrest was at best strained. Just as it makes no sense to call a cell phone a container for the purposes of search incident to arrest, like Riley, or search of an automobile, like we've discussed on this channel before under the Supreme Court case Camus, it makes no sense to call a cell phone a container for the purposes of probation. And finally, the court addresses the language that we have in Riley dealing with cell phones. The third factor, the court in Riley used a sweeping language to describe the importance of a cell phone privacy. The term cell phone in itself misleading shorthand. Many of these devices are in fact mini computers that also happen to have the capacity to be used as a telephone. They could just as easily be called cameras, video players, Rolodexes, calendars, tape recorders, libraries, diaries, albums, televisions, maps, or newspapers. A cell phone search would typically expose to the government far more than the most exhaustive search of a house. A phone not only contains in digital form many sensitive records previously found in the home, it also contains a broad array of private information never found in the home in any form, unless the phone is. The court concludes that even though Mr. Lara's privacy interest was significantly diminished as being someone on probation, he still didn't give up his rights completely, and given the broad types of information that could be found on a cell phone, the court finds that the interest is very significant. Now moving on to the government's interest, the court identifies that probationary searches have two governmental interests. One, we try to reduce recidivism, and number two, we try to integrate individuals into community. And supposedly, when we have searches of probationary's home, that's how we promote these two governmental interests. And the probation officers testify that they need to search the cell phone, especially in cases such as Lara's, where he has previously been convicted of a drug-related offense. The probation officers explain that because drug-related cases often involve cell phone devices, because after all, in order to have a transaction, the conspiracy to distribute narcotics people speak on cell phones. They send text messages, pictures, and so on. And because of that, the government says they need to have a search of the phone as part of a probationary search. Here's what the Ninth Circuit says. We recognize that Officer Ortiz searched Lara's cell phone knowing that he had been convicted of a drug crime, and knowing that drug traffickers often use cell phones to arrange sales. Given the ubiquity of cell phones, almost any crime involving more than a single person, and indeed many crimes involving just one person, would entail the use of a cell phone, which can be used not only for placing calls and sending text messages, but also for sending emails, looking up directions, and conducting internet searches on various topics. This ubiquity cuts against the government's purported heightened interest in conducting suspicionless searches of the cell phones on probationers with controlled substance convictions. The Ninth Circuit concludes that the search of Lara's cell phone was an unreasonable one, because given the circumstances, the amount of information that was found on Lara's cell phone, and Lara's interest, even though diminished, was still significant and more important and weighed more than the government's interest. And of course, with this suppression, all information found on the cell phone and anything derived from there should be suppressed from trial. What do I mean by that? Here, the search first revealed the picture of the firearm and the conversation between Lara and somebody by the name Al. Of course, that conversation has to be suppressed and cannot be used against Mr. Lara in court. But the forensic lab also revealed the location where the photo was taken, and using that information, the officers then went to the mother's home where they found the firearm. All of that data, as well as the gun, must also be suppressed as fruits of the poisonous tree. That is the doctrine that we use when we're saying that the Fourth Amendment has been violated. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post on YouTube, you'll be first to know. And if you're listening to the podcast version of this recording on Audible or Spotify, give my podcast a 5-star review rating. And finally, if you're interested in the month of December of purchasing one of these Do Not Arrest This Person t-shirts, put in the code THANKS2022 to receive a 10% discount. Thanks for watching.